Hi everyone, and welcome back to the Flow Migration Law channel. I'm Jay, the principal lawyer here. When you're planning your future in Australia with your partner, that plan almost always includes your children. And the partner visa process is designed to help unite families. But how do you include your children in that application is one of the most common topics we handle. And it's an area where the details really matter. Before we jump in, just a quick reminder. This video is for general information only and isn't legal advice. Your family's situation is unique. If you need guidance for your specific application, we really encourage you to get in touch with a registered migration agent or an immigration lawyer. Alright, so let's start with the fundamentals, including children who are under 18. Many people think this is just a simple box ticking exercise, but your family structure is the key. The first scenario is the most straightforward. If the child is the biological child of both of you, the applicant and your Australian partner, the sponsor, then you actually cannot include them in your partner visa application. Why? Because that child is very likely already an Australian citizen by birth or a descent. They don't need a visa. In this case, their Australian birth certificate listing both you and your partner as the parents is the main document you'll need to prove their citizenship. So that's the simple one. Now for the second and much more common scenario. The child is from a previous relationship. This is what we call a stepchild. This is where you need an extra layer of documentation. The Department of Home Affairs needs to be satisfied that you have the legal right to bring your child to Australia permanently. This is all about protecting parental rights. So you generally need to provide one of the two key things. First, official legal documents like court orders that grant you sole custody or the right to decide where the child lives. Or second, and this is very common, written consent from the child's other biological parent. This is usually done on a specific form, Form 1229. It's a consent to grant an Australian visa to a child under 18. This signed form must be accompanied by a certified copy of that parent's ID, like their passport. If you can't prove this consent or a court order, your child's application can come to a complete halt. It's a critical step you must sort out early in your planning. Okay, so that's kids under 18. What about an adult children aged 18 and over? This is where the rules become much more specific and the burden of proof is heavily on you. To include an adult child in your onshore partner visa, they must be considered a dependent child. So what does that actually mean? In the eyes of the department, it primarily means they're financially dependent on you for their basic needs such as food, clothing, and shelter. For children aged 18 to 22, this is the standard bracket. You need to build a case showing your adult child is wholly or substantially reliant on you for financial support. They also must not be married or in a de facto relationship. Evidence for this would include things like proof they're living with you, bank statements showing you're paying for their living costs or education fees, and proof of their full-time study. Now let's talk about the over 23 question. There is a widespread belief that once a child turns 23, they can no longer be included as a dependent in an onshore partner visa application unless they have a severe disability. Now, while this is true for many other visa types, the migration law for partner visas, especially for the onshore A20 partner visa, tells a more thorough story. The regulations don't actually specify a hard age limit of 23. The core requirement is proving that the child is wholly or substantially reliant on you for financial support. This means if you can compellingly demonstrate that your child, who might be 23, 24 or older, is still fundamentally reliant on you for their basic financial needs, it is possible to make a case. However, I must be very clear, this is a complex area of law. The department will scrutinize these cases very closely, so seeking a professional guidance is strongly recommended before proceeding. A successful outcome requires a very high standard of evidence and a carefully structured case. One last quick point. What if you've already lodged your partner visa and then need to add your child? Yes, this is possible. You'll need to complete a Form 1436, which is for adding an additional applicant after lodgement, and provide all the supporting documents we've discussed like birth certificates and if needed that Form 1229. So as you can see, including your children is not always straightforward. Navigating the rules for children from previous relationships or proving the dependency of an adult child are some of the most complicated parts of a partner visa application. This is where having dedicated experience really matters. As a principal lawyer with over 8 years dedicated to Australian immigration law, I've worked with many families to navigate these exact issues. Your family's journey is unique. If your situation is complex, or if you're just unsure about the right way to begin, please reach out to our team at Flow Migration Law. We can help you understand your position and map out the next steps. Thank you for watching. If this was helpful, please give it a like and subscribe for more. I'll see you in the next video.